The broadcast is now starting. All attendees are in listen-only mode.
All right, good day, everyone. Thank you all for joining us today. This is going to be a wonderful webinar that we have for you today. The title is Trapped, the Effect of the Criminal Debt on Reentry. It's brought to you by ACLU, the American Civil Liberties Union, Community Legal Services of Philadelphia, and we are the proud host at the Sargent Shriver National Center on Poverty Law. Not only are we excited to have this because of the topic, but this is extremely ripe. It reflects a national trend where more and more states are actually ramping up collections on individuals with legal fees and legal financial obligations. And the way they do so is actually imprisoning people to make sure that they're satisfying their debts, regardless of their capacity to afford that debt. Now, just as some housekeeping matters, we want to make sure everyone's aware that if you do have any technical difficulties, we do have a number for you to contact. That number is 312-368-1168. That's Sarah Hart right here, and she'll be able to answer some of your concerns, or at the very least, refer you to the link that you'll be able to access tomorrow to get any of the information that you're able to miss today. And also, this will be a question and answer session, but the questions will be at the conclusion of the presentation, so please get those together and prepare to send those to us, and we'll try to review those and get to many of those as possible. In terms of who we are the Sargent Shriver National Center on Poverty Law, and we're an advocacy organization that provides national leadership in advancing laws and policies that secure justice to improve the lives and opportunities of people living in poverty. And this is actually an interesting intersection between two of our units, one of which being the Asset Opportunity Unit, which takes action against poverty by advocating for policies that expand asset building opportunities for all, and also our Community Justice Unit, which litigates and advocates on behalf of men and women with criminal records to lower or eliminate barriers imposed on them because of past mistakes. Now, we're going to have a wonderful panel with some incredible panelists. They're going to be talking about all sorts of things, not only just going into the justification that states use and localities use for imprisoning debtors, but also more specifically going into the effects that these particular policies have on debtors in our society. Without any further ado, we'll go into our illustrious panel today. We got a lot of materials that we're going through, so I want to make sure we get straight to the panelists who can talk about them more detailed. Carl Takei is from ACLU. He's from the National Prison Project, where he litigates prison conditions and various lawsuits on behalf of that population. We also got Eric Balabin, who's represented over 75,000 prisoners in class action lawsuits challenging unconstitutional conditions of confinement across the country. We're also lucky to have Sharon Dietrich. She's a managing attorney at the Community Legal Services of Philadelphia, where she represents low-income persons in employment matters, such as criminal records, family and medical leave, unemployment compensation, and her work focuses on removing employment barriers, preserving jobs, and gaining access to employment-related benefits. We also are happy to have today Rebecca Vallis, who is formerly with the Community Legal Services in Philadelphia, but now she is known for her work at the National Organization of Social Security Claimants Representatives, where she works, amongst other things, on ensuring that individuals are awarded the benefits that they're entitled, and she engages in systemic advocacy, community education, and outreach. Now, to give you an idea of the sorts of things we'll be discussing today, we have prepared a brief agenda. Before we go into that, I want to make sure to honor the diversity of our audience today. We do want to say we're thanks to have organizations, not just advocacy organizations, but governmental entities. And this is an educational program. And if there are any instances or anything that you would like to discuss further, we're happy to have any discussion beyond the context of this webinar. But most importantly, this is just for educational purposes. We aren't expecting organizations who listen to this and to take this as action items, because we do recognize that LSC and non-LSC funded participants are taking place on the call. Now, in terms of our agenda, we will be talking about criminal debt, the scope and the impact of that, and then we'll go to when criminal debt actually relates to incarceration and becomes incarceration and the effects of that. And then we'll give some actual examples, put a face to the issue, not just describing statistics, but also examples of reforming criminal debt policies, how we can actually do that, and examples of reforming debtors' prison policies. All those have very nuanced ways to approach them. We have Sharon Dietrich and Rebecca Vallis, who will be honoring us by discussing sections 1 and 3, and Eric Balabin and Carl Takei discussing sections 2 and 4. At the conclusion of this, we will discuss questions, but in the meantime, without further ado, if we can cede the mic to Rebecca Vallis and Sharon Dietrich to discuss criminal debt, the scope and impact. Thank you very much.
Thanks so much, Todd. Are you able to see my screen?
Yes, we are. and we're expanding your slides as we speak. Thank you very much.
Fabulous. All right, well, thank you so much for having us today. Your introduction provided a great background for, I think, why this is an intersection of folks who typically work on criminal-related issues and prisoners' rights and also civil legal services. This is an issue that has really become something of a home to really a wide array of advocates who all care about the same client population. So just to provide a little bit of background about the scope of the issue, how many people it impacts, and kind of how it manifests. Criminal debt has really become something of a rising national issue. As Todd said in his opening, I think people typically use the cliche that one pays a debt to society. Unfortunately, what criminal debt has really started to mean is that in addition to paying a debt to society, you end up facing a financial debt at the end of doing your time, or even if you haven't been convicted in some cases. These debts can add up to many thousands of dollars and really end up being something that can reach crushing amounts of debt. Another phrase often used, and which you'll hear throughout this presentation, is legal financial obligations. And LFOs, or criminal justice debt, as you'll often hear it called, can really, it describes a broad array of types of user fees, court costs, restitution, bail forfeitures, pay to stay or jail fees, public defender fees, and such. You'll hear a greater discussion of that later on in the presentation, but it's really quite a broad net that we're talking about here today. So the origins of really this national rise that we've seen in criminal debt are many, and they include the fact that states and localities have been experiencing significant budget stress, looking for places to find revenue wherever they can. In addition, unfortunately, one of the sad truths is that the population that we're talking about who is impacted by criminal debt has little political clout. We're talking about so-called ex-offenders, people who have interacted with the criminal justice system, not a very politically popular population, and one that people are typically more comfortable going after when it comes to trying to seek revenue. In some cases, such as in Philadelphia, media pressure has played into the equation. Philadelphia is a prime example of this because there was a series of stories in the Inquirer a few years ago that really kicked off Philadelphia's entry into the world of aggressive criminal debt collections. And so what we've seen is really a proliferation of fees and fines, as well as much more aggressive efforts to collect. A report released in 2010 by the Brennan Center, which examined the practices in 16 different states. They chose to look at the states that I've listed on this slide because they were the states with the greatest prison populations in the United States. That study found a number of different trends across those 16 states, and which seem to be representative of the nation as a whole. Those trends include states and localities introducing new fees and new categories of fees, such as a popular new fee is the so-called pay-to-stay or jail fee, which operates something like a hotel cost for the pleasure of being incarcerated for a night or longer. Another trend noted in the study by the Brennan Center is that the dollar amounts of fees have also increased. So in addition to new categories, also the fees falling into each category are themselves more burdensome. Another trend noted is more aggressive collection efforts. I noted Philadelphia as an example of this, and you'll hear more about that later on in the presentation. And all of these trends really without regard for the impact on people who are seeking to re-enter into society and to rebuild their lives. What I'm showing you here is just a snapshot of a docket sheet of an individual who interacted with the criminal justice system in Pennsylvania, happens to be Cambria County. But you can see from this screenshot just the wide array of both types of fees, the number, and the fact that the amounts, while they might seem small in isolation, they can really add up. So in many cases, what you end up seeing, and like the instance of this person here, and I should say this is just a partial screenshot, this isn't even the entire array of fees that this person is being chased for, the user fees and the other kinds of costs and such that get tacked on, added to interest and everything else, can often exceed the actual fines that a person is penalized for, or restitution as well. So as I noted, it's a large and growing problem and a national one. Here's a list of the types of legal financial obligations, some of which I named in my opening. And you'll hear more about this later from Sharon Dietrich, who's going to describe why it's important to pay attention to which kind of fine or fee you're talking about, because they often have different laws and rules and policies that can apply. A little bit of background that folks on this webinar are probably very familiar with, so I'll go through very quickly. This is part of and very much related to why this is a growing and large-scale problem. Just put bluntly, the United States has a mass incarceration problem that many of the people on this webinar study and work on and are well aware of. You can see the population of individuals who are either in prison or on probation or parole skyrocketing from 1980 to 2007. The ratio of adults behind bars is tremendous, 1 in 100 U.S. adults. And I won't read the rest of this slide, but just trying to provide a little bit of context for the fact that the number of people who end up facing criminal debts is both enormous already and growing year by year. A note on the final bullet, many individuals can end up facing criminal debts even if they have not been convicted of a crime. You'll hear a little bit about that in discussion of what's going on in Philadelphia, but bail forfeitures is just one instance. Pay-to-stay fees is another, where individuals who end up actually being acquitted or having the charges dropped can end up still with a debt at the end of the day, even though they weren't convicted of a crime. Now, given the nature of the financial situation that many of folks who have interacted with the criminal justice system find themselves in, really this problem is often described as states and localities trying to get blood from a stone. And I think that's an apt phrase, given that the population that we're talking about, 80 to 90%, is poor enough to qualify for indigent defense or a public defender. Folks, when they are leaving incarceration, many of them expect to go to shelters. Most of them lack high school diplomas or any more education than that. And the likelihood, and made worse by the economy that we're currently in, is that folks will still be unemployed after they're released, even 1 year later. So really not a population who can afford to make payments on crushing debt. And that's reflected in many states and localities' own data. When they look at the population they're trying to collect from, Florida, Washington State, and Philadelphia are just 3 examples who in their own reports and their own data collection realize and actually say explicitly that the populations that they're seeking to collect these debts from are ones that are not likely to be able to afford to pay. So part of why this webinar is being hosted by the Shriver Center and why the folks who are interested in this issue include many legal services lawyers like Sharon and like myself is because criminal debt can operate as a serious barrier to not just reentry but to climbing out of poverty while you're trying to reenter. So folks who end up owing criminal justice debt can find themselves in something of a never-ending cycle of penalties. Can't make a payment, so interest is added. You need to get into a payment plan because you can't afford the whole thing. You have to pay a payment plan fee. Can't miss a few payments in a row, your case gets sent to collection, and collection fees or attorney fees get tacked onto the top. It's a never-ending cycle of debt. A study in Washington State looked at individuals who were being chased for criminal justice debt and found that even making payments of $100 a month, which on average would have been 10 to 15% of the individual's income, those folks would still be in significant debt 10 years later across the board. So it reflects that this is really a form of debt that not only is crushing but can be long-term and can result in a lifelong entanglement with the criminal justice system. My last bullet just notes that this is only one source of debt we're talking about. We're talking about a population who already, in many cases, struggles with back due child support, student loan debt, and many other crushing forms of debt. This is just one more sort of compounding the problem. So with that, I'll turn it over to Sharon.
Thanks, Rebecca. My first job is to talk to you about how criminal debt is different from civil debt. And to really know a lot about the criminal debt in your state, you need to take a look at your specific state law. So I'll make some generalities, but please take a look yourself to make sure that you are learning what you need to about the law in your state. First of all, often these judgments are automatic. They're not taken with the same kind of due process that you find in other civil judgments. Second, standard debt collection laws often do not apply. For instance, under the Fair Debt Collection Protections Act, generally fines are not considered a quote-unquote debt that is covered by that statute. Although I would call to your attention, if you're interested in this issue, a case called Barlow, where a family member who posted bail for a woman for her son was found to have a debt that was covered by the statute. But in general, debt collection laws will not apply. And that's quite important because often the level of collections that are seen here are quite ferocious in nature, where the debt collectors armed with the ability to threaten somebody going back to jail, whether or not that's true, really put heat on people. Often the criminal debt is not dischargeable in bankruptcy, although this is not exactly my area of expertise, but I will flag that. And then finally, there can be extraordinary collection methods. So for instance, in Pennsylvania, we have almost no wage garnishment, but in fact, these debts can be garnished, and there's no state law limit on the amount of the garnishment. If you're in the same situation, look at the Consumer Credit Protection Act, which does establish limits on the amount of somebody's wages that can be garnished. Also, tax intercepts are quite common in these types of cases. Next slide, Rebecca. The consequences of criminal debt are many, as you can see here, and I want to focus on 3 of them. One is that you can violate your probation or parole if you don't meet the payments that they want. And that's also relevant to your public benefits eligibility because, for instance, in order to get TANF, SNAP, or SSI, you can't have a violation of parole or probation going on. There was a piece of litigation called Clark versus Astru that said there has to be more than a bench warrant. There has to be an actual adjudication of a violation. But nevertheless, there is the threat of those benefits being potentially terminated or prevented because of a VOP. In addition, you may have state law requirements about public benefits and state-funded public benefits. In Pennsylvania, we have a requirement that you be in and compliant with a payment plan in order to get state-funded benefits of some sorts. Finally, we find that criminal debt also impacts on our employment practice because, for instance, we are not able to get people pardon applications filed or expungements fully implemented if people owe criminal debt. And one last slide for me. Any discussion of the subject has to tell you about Turner versus Rogers, a Supreme Court decision well known to the legal aid community. If you get into the whole subject of ability to pay these debts, you'll want to look at Turner versus Rogers because it spells out what due process requirements are needed. And with that, we'll turn it over to the ACLU to talk about debtor's prison.
It's easy to see, as was mentioned by Carl Takei and Eric Belobin's article, that as much as it sounds like hyperbole, that the whole notion of someone being in prison for being poor, you can actually be tethered to the criminal justice system just because you're poor and have interactions for a lifetime. So without further ado, let's go ahead to Eric Belobin and Eric Takei so we can describe the different ways in which there's reforming criminal debt policies like these so we can fight them and do something about them.
Thank you. I'm going to discuss the legal background and what we know about the prevalence of debtors' prisons across the country and what we've done to investigate them. My colleague Carl Takei will discuss the impact of debtors' prisons. 30 years ago, in Bearden versus Georgia, the Supreme Court held that a criminal defendant could not be imprisoned for his non-willful failure to pay court debts. A little background on the case. In October of 1980, Danny Bearden was sentenced to 3 years of probation in order to pay $750 in fines and restitution for burglary and receiving stolen property. He borrowed from his parents to keep up payments, but soon fell behind when he was laid off about a month after being convicted. Mr. Bearden was illiterate. He hadn't finished high school, and he was unable to find another job, and his probation was revoked. And he was ordered to serve the remainder of his sentence in prison because he could not pay the $550 he still owed. He remained behind bars for 2 years. In 1983, his case reached the U.S. Supreme Court, which held that imprisoning a probationer who could not pay his legal debts through no fault of his own violated the Equal Protection Clause of the 14th Amendment. The court held that sentencing courts must inquire into the reason a defendant has failed to pay legal debts and can only sentence to incarceration a defendant whose failure to pay was willful. Today, states have laws that provide due process protections to criminal defendants before certain legal financial obligations, LFOs, are imposed, and before a defendant who does not pay his LFOs can be punished. Some of these are by state statute, others are by their state constitutions and common law. Despite the Supreme Court's decision in Bearden and these state laws, investigations by the ACLU and the Brennan Center and other organizations have found that men, women, and children continue to be incarcerated simply because they are too poor to pay their LFOs. In 2010, the ACLU and the Brennan Center jointly released reports that looked at criminal justice debts across the country. The ACLU focused on 5 states and Brennan Center looked at 15 states, and each found that in every state they studied, the courts imposed LFOs on criminal defendants without an inquiry into their ability to pay these debts, and jailed those whose failure to pay LFOs was not willful. Earlier this year, the ACLU of Ohio issued its own report, finding that courts in 7 of the 11 counties it investigated had failed to follow the Ohio Constitution and state law, requiring both an inquiry into a criminal defendant's ability to pay before setting LFOs, and a due process hearing finding that the defendant's failure to pay was willful before jailing him. None of the states the ACLU and Brennan Center investigated had in place an infrastructure that could provide data on the prevalence of debtors' prisons, the circumstances under which LFOs were imposed, or identify when and how often defendants were jailed for failing to pay their LFOs. We in the Brennan Center had to develop a methodology on our own for investigating, which included speaking with court administrators, judges, public defenders, and jail personnel, as well as current and former defendants. We also engaged in court watching, which involved our sitting and watching proceedings when LFOs were imposed, or when defendants were back in court for failing to appear at subsequent collection or contempt proceedings. We also reviewed case dockets and individual records to determine what happened in individual cases. And we filed public record requests to gather relevant court administrative procedures and data on court administration costs and revenue. In addition to not having data to show the scope of debtors' prisons, the states we reviewed also did not collect and produce data on whether their efforts to impose and collect LFOs led to net revenue gains. While some states like Washington did aggregate data on the amount of revenue they gained through collection efforts of unpaid court debts, they did not determine how much all of their collection efforts cost, and in particular did not assess the cost of incarcerating those with unpaid debts compared to the amount they collected from these jailed defendants. Despite the lack of data, counties view unpaid court debts as important revenue. We highlighted in our 2010 report the town of New Rome, Ohio, with a population of 60, which generated almost $400,000 annually in fines and costs. We also focused upon Orleans Parish, Louisiana, where court-imposed fines and fees accounted for more than 1/3 of the court system's operating budget. However, in Orleans Parish, we were able to calculate the cost of incarcerating those for unpaid court debts, since the city of New Orleans pays the sheriff a per diem for each prisoner at the jail. We determined that the city was paying substantially more to jail debtors than it could ever collect from them in unpaid court costs and fines. We pulled 2 examples of a number from our report to illustrate this. The first is the case of Sean Matthews, who is a construction worker who pled guilty to marijuana possession and was assessed a total of $498 in LFOs. 2 years later, he was arrested for non-payment and spent 5 months in jail awaiting a hearing. The judge later released Mr. Matthews after waiving his unpaid LFOs. Second example is Javon Perryman. Mr. Perryman also pled guilty to marijuana possession and was assessed $448 in LFOs. He spent a month in jail for non-payment, even though his public defender argued he had no money to pay his debts. He was released after his lawyer stated he would appeal his continued incarceration. Taking the amount of their LFOs, the length of their incarceration, and the per diem payments from the city to the sheriff, we could show that both Mr. Perryman and Mr. Matthews, the decision to arrest them for non-payment was a money-losing proposition for the parish. And I'll turn over the remainder of this part to my colleague, Carl Takei.
All right, let me see if I can enlarge this. So I'm going to talk about the human impact of debtors' prisons as well as the impact on cities and counties that impose them and the overall impact on the criminal justice system. Starting with the human costs, as Rebecca said, criminal justice debts can follow a person for years and years. And when you add incarceration to the mix, it makes those costs even more acute. One example from our recent report in Ohio is a man named Jack Dolly. He was an alcoholic in the mid-1990s, which led him to a great deal of criminal justice involvement. He ended up convicted of a number of crimes, including a DUI, which caused him to be assessed nearly $1,500 in fines and costs. After being released from prison, he sobered up and began to work on paying down his debt. But as recently as last year, his decades-old fines were continuing to trap him in a cycle of imprisonment and further debt. That cycle began in 2007 when he suffered a back injury that made it difficult for him to find construction jobs. Because of that and the combination of his felony record, he had great difficulty finding steady work. He started to fall behind on his payments. He was repeatedly jailed. He lost his house and began living with friends, and kept trying to find short-term construction jobs, which then resulted in re-injuring his back. He described it as, quote, pretty much a vicious cycle. I'd go do my 10 days, and then they'd set up a court date, give me another 90 days or so to pay or go back to jail. And in the meantime, he had great difficulty finding work. In 2012, he finally found a job that didn't involve so much physical labor. But within a few weeks of starting that job, when he was about to deposit his first paycheck, he was arrested for non-payment of fines. And when he appeared at his contempt hearing, the judge lined him up with a group of other debtors, explained the charges of non-payment, and did not inquire into Jack's or anyone else's financial circumstances. He ended up jailed for another 10 days and was fired from his new job because he had missed so many days of work. He also lost his driver's license. Another example is Tricia Metcalf, who is a single mother of 2 children, 17 and 13 years old. She was convicted in 2006 for passing bad checks and assessed more than $3,000 in fines and costs. And she has worked in fast food restaurants and for temp agencies, but has had difficulty finding long-term employment. During her periods of unemployment, it's especially hard for her to keep paying her fines consistently. And even though she asked the judge about doing community service or some sort of alternative sanction in lieu of the fines, he refused. She ended up selling her car to be able to pay her fines, but even that wasn't enough. And she resulted in, this resulted in 5 sentences of incarceration for failure to pay. At one point, the judge actually ordered her to pay either pay $2,000 on the spot or go to jail for 37 days. That resulted in a 37-day jail sentence. This has all affected her relationship with her children. Her son, for example, ended up moving in with Tricia's parents because, as she put it, having the constant threat of, Mommy didn't have the money for her fines this week, so we're going to have to go stay at Grandma's house, exacerbated all of his own problems at school, and she said it was just easier for him to go in and move in with her parents. In addition to imposing human costs on the individuals who are trapped in this vicious cycle of debt and imprisonment, this wastes taxpayer money and resources. As our investigations found, there's very little systematic collection of data and nothing showing that these aggressive collection measures actually make money, and certainly not enough to disrupt, to justify the disruption in the lives of the men and women who are affected by these practices. Most recently in Ohio, we have compared the amount owed, the amount collected, and the costs of incarceration and warrants. So with Jack Dolly, the example that I just mentioned, in addition to all the human costs, the series of incarcerations, even just the most recent set, resulted in a net loss of nearly $2,000 to the county. Tricia Metcalf, the warrant and the incarceration resulted in a net loss of more than $3,000, which is more than the total amount of her fines and costs. There are several other examples from the report, and this is linked in the resources page, so I'd urge you to look at that. The other major issue is the impact on the criminal justice system. It creates an appearance of impropriety when judges are squeezing money from criminal defendants to keep the courts running. The defendants know this. Anybody who walks into the courtroom and sees these cattle calls can look at that and realize that it has an appearance and arguably a reality of funding the court system and not serving the interests of justice. It also has a disproportionate impact on racial and ethnic minorities because of the existing disparities in the criminal justice system. And it results in a two-tier system of justice. Much like laws against begging equally protect the rich and poor by prohibiting both rich and poor alike from begging under bridges, for those who have money, they can pay their fines and move on quickly with their lives. For those who don't, they get trapped, as Jack did and as Tricia did, in these cycles of debt and imprisonment that are incredibly difficult to escape. And so that, I think we can move on to the next stage in Rebecca's presentation.
Great, thank you for that piece. We've so far gone over the origins of this practice, how this practice functionally makes it a crime to be poor, the human impact of this practice. Now we've had a chance, thanks to that presentation, to see what it's like to be dealing with this issue. Now, Rebecca and Sharon, if you can get your slides together, and we'll talk more detailed on how to reform this practice so we can have fewer people having to deal with this sort of discrimination.
Thanks, Todd. To get started with your advocacy in this practice, very few people on this call, I'll bet, are very familiar with the law that governs court debt, or legal financial obligations as we've been calling it. I recommend that you do two things to get started. First is figure out what kind of debt your clients in fact have, and then figure out what the state law has to say about each of those kinds of legal obligations, because typically the different legal obligations have different rules, and it's kind of a mistake to think of them as though they're monolithic. They are unique. You even need to identify which are the most significant ones, because, for instance, when we looked in Philadelphia at what our clients mostly owed, bail forfeitures were the #1 debt by far, followed by supervision fees. So get the lay of the land, figure out what your goals are. I would suggest that potentially your goals should be reducing or eliminating the debt as the first goal, and secondly, to the extent that it cannot be eliminated, figure out how clients might get into reasonable payment plans that don't overburden them and cause some of these consequences we've talked about. When we started to do our canvassing of the landscape here in Philadelphia, we discovered that although our public defender friends knew something about these court debts, in fact, there was much that they did not know, because this topic did not fit their practices neatly as well. And we ended up having to spend more time, in fact, talking court administration and reviewing the law to figure out what was going on and what advocacy strategies we might have. In fact, I would say that the biggest thing that we've done that has improved the world here is to help force the courts to create systems where they didn't really have very good systems in place at the time that we started working on this. So for instance, their so-called payment plan conferences were terrible in terms of process. We pushed on that. Bail hearings to vacate bail forfeitures, we essentially caused them to have. They were not even having these hearings on the record. Next slide, please. As I've said, not all the financial obligations are the same. Figure out what the rules are, figure out which are the biggest burdens. And in terms of not all of the goals being the same, I would point out that restitution is the one, the legal obligation that is least likely to be excused. And it will also be the least popular one for you to try to reduce. As a strategic matter for advocates for criminal defendants, former criminal defendants, you will find yourself in conflict with victims' rights advocates who otherwise might be on your side, we have discovered, because they understand the role that this debt plays on the defendants, and also they want to see restitution get priority over things like court fines that just finance court operations. Next slide. A little bit on community legal services work in this area. We got into this when our courts started trying to collect suddenly $2.5 billion with a B, dollars of all kinds of court debt that went back to the 1970s. The debt was extraordinarily unreliable. They had no documentation to verify the existence of much of it. And so we began a very ambitious campaign to confront the effect on our clients. We've worked quite a bit with the ACLU of Pennsylvania, with the Defender Association, others, and the types of things that we have done have included individual representation, which is part of how we make them develop systems, is that we represent individuals, reduce their debts, get them into payment plans, but also get a better sense of how things are working. We do a great deal of community education and outreach. One anecdote that will always stay with me is that Rebecca and I once took a bus to North Philadelphia to give a training on criminal debt to clients. And when we got off the bus, so did almost everybody else on the bus, because people from all over the city were going to our training. We do advocacy with the city and the courts to try to make them develop procedures that are fair, try to get them to write off some of the debt. We do impact litigation. So for instance, the bail forfeitures being our biggest category of debt in this area, we have done appellate cases to our state intermediate appellate court to try to impact, to question whether the processes that are being used by Philadelphia are consistent with what the state standards for bail forfeiture, revocation, or reduction are. And finally, we've done quite a good deal of media around this, including Rebecca steered us through the making of a documentary with law students from the University of Pennsylvania. Much of our media will be in the materials that are available to you after this webinar is over. And the media has played a very large role in putting pressure on our court and city officials to make the procedures fairer. Rebecca?
Thanks so much, Sharon. So I'm just briefly going to run through a few examples of other models for advocacy. Some of these involved legislative advocacy, some of them involved lobbying campaigns in partnership with multiple organizations. It really runs the gamut. And I'm going to do this briefly because these models are all described in great detail in multiple of the materials that Schreiber is going to be making available after the webinar. Washington State is one example of a state where advocates have been successful through advocacy in improving the landscape significantly for people facing criminal debts. In Washington State, the problem that they were dealing with was interest. Folks were going into prison and then coming out at the end of their sentence and finding that interest had accrued on the debt that they had gone in with the entire time they were in. So the example provided in this slide was one gentleman went into prison with $35,000 of debt, came out with $100,000. Columbia Legal Services, the ACLU, and the Washington Defender Association, among others, partnered successfully to end up with legislation that permitted interest waivers upon release, which was a huge deal for folks in Washington State. Another example of successful advocacy has happened in multiple counties in Florida. One example is Leon County, and the Brennan Center partnered with local folks there to try to tackle a problem that folks were seeing in Florida. The problem in Florida was manifesting as arrest warrants that were being issued for people who were missing payments on criminal debts and then subsequently not showing up to explain themselves. Cost-benefit analysis was what really tipped the scales in Leon County. The quote from the one of the news articles describing the change and the advocacy success was that the manpower required, in this case to collect some $80,000 in unpaid criminal debts, was a tremendous burden, and it was found to have interfered with the efficient administration of justice. So cost-benefit analysis sort of won the day in Leon County among some other counties in Florida, and the collections court was closed, arrest warrants were lifted, and better policies were taken under consideration and have begun to be implemented. Another example is Maryland. In Maryland, a legislative advocacy campaign by the Brennan Center and by a program in Maryland called the JOTF was a successful partnership that ended up with legislation to tackle the problem of fees for parole supervision that were really accumulating and becoming burdensome debts at the finish of people's sentences. There were categorical exemptions in place under Maryland law, for instance, if you were a student or if you had a disability, but people in practice were not actually obtaining those exemptions, and they were ending up being stuck having to pay the parole supervision fees. So the success was legislation requiring that parolees be informed of the exemptions, that some of the barriers be removed, and that they be assisted in applying and understanding them. Another advocacy success is from Massachusetts. In Massachusetts, impact analysis was used in the Commonwealth's recent consideration of whether or not to impose a pay-to-stay jail fee. So in sort of a unique twist, the state legislature actually thought in advance about what might happen, what might be the potential impact if they were to implement such a fee. So to that end, they established a commission to conduct an impact analysis. They appointed folks from the Department of Public Safety, the Correctional Systems Union, the Sheriff's Association, Prisoners Legal Services, and others to be members of that commission and to partake in the evaluation. The answer at the end of this impact analysis was that they shouldn't impose the fee. They actually examined not just technical financial costs and benefits, but also the collateral consequences of the impact of such a fee, and they found that it would be a barrier to reentry and would have other collateral costs down the road. And the final model I'm going to describe is something called the Clapham set, which was an experiment in Suffolk County, Massachusetts. It was launched in 2008 and it ran for 3 years. And what it was an alternative workforce development model. It was a partnership between a former prosecutor named Robert Constantino and a group called Street Safe Boston, plus the Ministerial Alliance and the Boston courts. And what they did was to target young folks, specifically court-involved men, who and to provide them with a curriculum for a set period of time, the goals of which were skill development and job training, substance counseling, mental health counseling as appropriate. And in addition to being beneficial in those ways, at the completion of the program, if you successfully completed the program, you would get credit towards your criminal debts. It was a very small sample, just 26 folks who participated over the course of 3 years, but that pilot did have pretty tremendous outcomes in that only 5 individuals who participated in the program are known to have reoffended, which would represent just fewer than a 20% recidivism rate compared with the average state recidivism rate in Massachusetts, which is 50%. So I'll leave it there and turn it back over to the ACLU.
Thank you, Councilor Vallis and Councilor Dietrich, for such a wonderful blueprint of what we can do to reform criminal debt policies. Now, if we can turn to Eric Balabin and Carl Takei to talk about what we can do to reform prison policies.
Yes. The ACLU, because of our national affiliate structure, is able to experiment with a lot of different strategies in different states and engage a lot of state and local advocacy. And because a lot of these practices center on city and county courts, they often involve very local policy change work. One example is, I'm going to do 3 examples: New Orleans, Michigan, and Ohio. There are others, but if we pick these 3 for the presentation. In New Orleans, it's very, very local. And in connection with our In for a Penny report release in 2010, we used public advocacy to highlight the problem and the fiscal dysfunction and the appearances of impropriety all associated with the way that particularly New Orleans municipal courts operated. They routinely imposed fines or time sentences, which are sentences in which the judge tells the defendant, you have to either pay this amount of money now or you will be sent to jail. As a result of this advocacy, we successfully achieved a change in municipal court practices so that they no longer imposed fine or time sentences. Now, the one question about this victory is that it's based on a change in practice, and so there's no written policy, and there are some concerns about actually having that change stick. Michigan is another model where we started off with a litigation push. We simultaneously filed challenges on behalf of 5 people who were illegally jailed for being too poor to pay their court fines and fees. They were, and one example is Kyle DeWitt, who his original crime was catching smallmouth bass out of season, and he was ordered to either pay $215 by 5 p.m. the day of his court hearing or serve time. Kristen Preston is another of our clients who was ticketed for underage drinking and even denied the possibility of a payment plan. Dante Smith, who was driving on a suspended license and given an hour after he pled guilty to come up with $415 in costs and fines or else be jailed. And the final client is David Clark, who was given the choice between immediate payment of $1,250 or 90 days in jail. We filed emergency motions to appeal the orders sentencing each of these defendants to jail time, as well as emergency motions for bond pending appeal based on the risk that these sentences would be served before the appeal could be fully litigated. Simultaneously with the filing of these motions, we did media outreach, got some media attention, and increased public awareness. The problem is that even though in each of these 5 cases we managed to reach good results for the individuals, this failed to result in any systemic change. Because of that, the Michigan affiliate has been continuing on a different track, engaging with the Michigan State Planning Body to develop and recommend specific changes to the way that the Michigan courts operate, as well as the guidance that's given from the State Court Administrative Office regarding the fines and fees collection. These recommendations are currently in draft form from the Michigan State Planning Body, which is should be issuing the final version of the report soon. And the proposed amendments require that before sentencing a defendant to incarceration for failure to comply with a court order to pay an LFO, the court has to determine that the defendant can actually comply with the order without manifest hardship and has failed to make a good faith effort to do so. It also requires courts to consider payment plans and payment alternatives in cases where the court finds that the defendant is unable to comply with an order to pay without manifest hardship. In addition to the work with the MSPB, the ACLU recently filed an amicus brief co-authored with the Brennan Center and the MSPB that highlights the troubling sentencing practices that exist in Michigan and urging the Michigan Court of Appeals to clarify the ability to pay determination criteria for lower courts so that the indigent defendant's constitutional rights will be adequately protected. And that's in State versus Bailey. The final example is from Ohio. And this, in Ohio, it was a public advocacy push with the constant threat of litigation behind it, but we successfully managed to reach resolutions without the need for litigation, which is something of a win-win for everybody. We conducted court watching and file review in several counties across the state, found that in 7 of the 11 counties we examined, there was definitive proof of debtors' prison practices occurring in those courts. So we compiled our findings into a report and sent this report out to the media as well as to the state Supreme Court and each local court, along with specific letters addressed to each local courthouse that we were investigating, and a separate letter to the state Supreme Court asking that the state Supreme Court provide specific guidance to the lower courts so that defendants' constitutional rights were protected. As a result of these letters, first, the Supreme Court agreed to prepare what's known as a bench card. It's basically a single-page laminated sheet for judges, magistrates, and other court officials describing the appropriate procedures for indigency hearings. Additionally, the court is going to offer training sessions to judges, magistrates, probation officers, and other court officials on the appropriate methods for collecting court costs and fines, and how to avoid the unconstitutional practices that we found in our report. Finally, the Supreme Court has expressed an interest in investigating any complaints about local courts that are acting improperly. Meanwhile, the municipal courts that we profiled in the report, most of them canceled their outstanding bench warrants for people who fell behind on payments. And we're now working with those courts to change their practices going forward. Mansfield Municipal Court, for example, just finalized a new policy in August of this year that sets forth detailed rules for how judges conduct the fine and fine non-payment hearings so that defendants' constitutional rights are protected. These new guidelines will make sure that the defendants are afforded a right to counsel and that the court makes a factual inquiry into the defendant's ability to pay and makes findings on the record about the defendant's ability to pay before imposing any incarceration sanction for a failure to pay. So with that, I think we can move to questions.
Yeah, thank you for that wonderful presentation. Thanks for the active participation of all those who are actually partaking in the webinar. We have a lot of questions for our panelists, and I'll get right to them. One question is from a researcher with longitudinal data relating to debt types and amounts for people out of prison, and they want to know what outcomes should they look at. Specifically, how does criminal debt impact reentry in terms of housing, employment? Do you all have ideas of how empiricists should study this data to be more of an asset in the advocacy realm? We can direct that question directly towards Sharon Dietrich, or since you mentioned briefly about the criminal debt aspect of it.
That's a great question, and honestly, I've been quiet in response to it because I'm somewhat not ready to answer it. Certainly the cost-benefit analysis that was discussed earlier would be a good thing to take a look at, because my sense is that because of the blood from a stone phenomenon, seldom is the cost of running after people met by what they managed to collect. But otherwise, it's a great question, and I wish I had more ready answers for it.
Another thing I want to make sure I outline is we do have any resources, any question that's asked. If we don't get it today, we will ask our panelists and see if we can make that information available later. The second question we have, one of many, is that there's already something set up called amnesty courts for veterans and homeless folks, and they're asking if maybe can create an equivalent for those who are dealing with these issues, debtors' issues. And has anyone heard of that sort of effort, and does that sound like a good idea, something like that can be incorporated into advocacy?
Well, I think the one caution here is that the collection of criminal justice fines and fees at this point is so deeply embedded in court practices that if you split off a separate court that is devoted to these issues, it may, in the same way that, for example, veterans courts do, work out better for the population that gets diverted into those courts, but it doesn't resolve the problem with the way that everybody else is treated in the entire court system. I think the best way would be to make sure that courts adopt specific and appropriate policies to protect the rights of defendants, and that they don't blindly sentence people to jail and don't blindly impose fees that are so high that it ends up sucking people back into the criminal justice system in a way that can create all of these unintended and inappropriate consequences.
Following up on Carl's comments, one of the problems is that the court systems are underfunded, and therefore these fines and fees become a vital revenue stream, which creates a series of perverse incentives for the courts to impose these fines and then to aggressively use their contempt powers and to collect the unpaid debts. So the adequate funding of court systems could go a long way to reducing those incentives.
Okay, thank you for that thorough answer. One person asked, why did you all at the ACLU specifically choose Louisiana, Ohio, and Michigan as a source for your study and the places where you decided to do your advocacy work?
We started out very ambitiously wanting to do a study of all 50 states and realized that would be impossible even with our affiliate structure. We were looking to choose states that were geographically diverse, ones also where there was some hope and expectation that working through the affiliates and with community partners, we could get some results in terms of reforms. So those were some of the main criteria that we used to choose the states that we ended up focusing on.
Okay, wonderful. I think we have time for one more question here. And the question is, what kind of advocacy projects have been done to fix problems with LFOs in the juvenile justice system, and how might efforts be different for those rather than for adults?
Well, one issue in the juvenile justice system that's unique is actually that oftentimes the LFOs can affect the parents as well for juveniles. And one of the stories that came in that first made the ACLU concerned about the debtor's prison issue was one of those cases where the parent ended up getting dragged into court and sentenced to jail time because of her son's LFOs from the juvenile justice system.
I just wanted to add, it's a great point the question asked to note that this is also an issue in the juvenile justice system, and one consequence that is resulting from that is that the jobs corps does not let people in if they have court debt.
I do want to mention the ACLU of Texas did successfully litigate a case on behalf of juveniles who had been incarcerated for failing to pay truancy fines. A case called the Luna versus Hidalgo County, Texas, out of the Southern District of Texas, the McAllen Division, and that could be a good source, the federal court, that could be a good source for anyone who's interested in looking how this issue is played out in terms of litigation and truancy fines.
Well, thank you all for your active engagement. Thank you, panelists, for your incredible expertise. Thank you specifically Rebecca Vallis, Sharon Dietrich, Carl Takei, Eric Balaban. Unfortunately, we are out of time. We will have our resource page, as you see on our thank you, which will include not only all the things discussed in terms of slides, but also other resources relevant to this topic. We'll also note all the questions that were posed and try to have answers from our panelists on that same site. So for those who feel like their questions weren't answered because of time constraints, we are sorry, but we will have those answers for you. Now, if we can ask that you complete the survey, there's a survey attached, and subscribe to the Schreiber Center for future events and information. Let us know how we can make this better, this webinar, and provide other webinars that may be useful for our population to know more about. And if you have any questions, of course, contact Kaylee Grant at kayleegrant@povertylaw.org. Thank you all so much for your time today and your expertise, and have a great day.